Hello, welcome to Legal Junction. Today we shall be talking about the doctrine of frustration in contracts. Frustration is a general word used to refer to events that makes the performance of a contract impossible. The Supreme Court defined frustration in the case of Attorney General of Cross River State versus Attorney General of the Federation as the premature determination of a contract that was lawfully entered into by parties owing to the occurrence of certain intervening events or change of circumstances so fundamental as to be considered by law to be striking at the root of the contract and which was beyond the contemplation of the parties. Some of the events that could frustrate a contract are war, new laws that renders the contract or its performance illegal, destruction of the subject matter of the contract, or cancellation of events which brought about the execution of the contract. Frustration can apply to any category of contracts, and it can apply irrespective of whether it was expressly provided for in the contract or not. For instance, in the case of the Attorney General of Cross River State versus Attorney General of the Federation, it was a contract between the federal government and the government of Cross River State, where the federal government agreed to be paying 13% of revenue accruing to the Federation account from offshore oil wells to Cross River State, considering the fact that Cross River State was a littoral state. Cross River State was considered a littoral state because Bakassi Peninsula and the Cross River estuary, which were contiguous to the Atlantic Ocean, were within the territory of Cross River State. However, with the ceding of Bakassi Peninsula to Cameroon in 2008, the federal government omitted Cross River State from the list of states that were entitled to 13% of revenue from offshore oil wells. Cross River State was aggrieved. They went to court. The Supreme Court considered that when the federal government was entering into these agreements or contracts with Cross River State, Bakassi Peninsula was within the territory of Cross River State. But now that Bakassi Peninsula has been ceded to Cameroon, it is no longer within the territory of Cross River State, and therefore the contract has become frustrated by impossibility of performance. The Supreme Court discharged the parties based on frustration. Also, the case of Uche Ajuna versus UAC described a situation whereby war could frustrate a contract. In that case, Uche Ajuna entered into a contract of employment with UAC. And one of the provisions of their agreement was that if Uche Ajuna's appointment should be terminated, UAC would have to give him 2 months' notice or 2 months' salary in lieu of notice. However, sometimes in 1967, Uche Ajuna traveled to the eastern part of the country, and the civil war broke out. He could no longer return to his place of work in Lagos. So he stayed back in Port Harcourt and started working with another subsidiary of UAC, where they paid him all his salary during the period which he worked. After the war, he wrote to his company in Lagos to repost him to Lagos. The company told him that he is no longer in the employment of UAC, that his contract has been terminated. They gave him 2 months' salary in lieu of notice, but he contended that he is still an employee of UAC. He went to court and told the court that he is entitled to 10 years' salary, which was the period for which he's still supposed to work before he retires. The court told him that the contract has been frustrated as a result of the civil war since 1967. The court discharged the parties. Finally, it is the duty of the court to decide whether or not a contract has been frustrated or has become impossible to perform. And whenever a court decides that a contract has been frustrated, the contract automatically comes to an end by operation of the law. Thank you very much for watching this video. My name is Ifoma. See you next week. Stay safe and stay out of trouble. Bye.